Good morning. This is the time and place for the zoning hearing cases for July 20th, 2011. My name is Bradley Collin, and I will be conducting the hearing as a hearing officer. We have two cases scheduled for today, and the relevant exhibits are posted on the panels located directly behind me. If you wish to speak, please write your name and address on one of the speaker forms which have been provided by the front door and submit it to our planner to my right. I would also like to inform everyone that the official proceedings of the planning hearing officer's hearing are recorded on tape as part of the public record. Notification of this hearing was accomplished by the use of public notices which were mailed to property owners located within 500 feet of the subject property, physically posted on the site in question, and placed in the local newspaper. The hearing will proceed as follows. I'll read the description of the application or request. I'll go through the reports and any letters or communications received from interested parties. The case planner will make a brief overview of the case, give analysis, and make a recommendation. The applicant will then be asked to come forward stating both name and address and will be asked to present the case within a 15-minute time limit. I'd also like to note, just as a heads up, that the applicant should go through each of the four required findings. We have two variances for today and demonstrate how each of those findings are being complied with the subject project. Others in support of or in opposition to the application and interested parties will be asked to come forward to speak, again, clearly stating both name and address with a 3-minute time limit. Lastly, the applicant will be given the opportunity to make any closing comments if desired in response to testimonies given by preceding speakers within a 5-minute time limit. The hearing will then be closed. Case will either be taken under submission or a decision may be made. Under the provisions of Title 30, Chapter 30.43 of the Glendale Municipal Code, a variance shall be granted if four of the required findings are present, and I'll read through the findings. That the strict application of the ordinance would result in practical difficulties or unnecessary hardship inconsistent with the general purpose intent of the ordinance. The second finding is that there are exceptional circumstances or conditions applicable to the property involved or to the intended use or development of the property that do not apply generally to other property in the same zone or neighborhood. Third, that the granting of the variance will not be materially detrimental to the public welfare or injurious to the property or improvements in such zone or neighborhood in which the property is located. And fourth, that the granting of the variance will not be contrary to the objectives of the ordinance. If the evidence presented in the application at the hearing meets the criteria just described, the hearing officer can either approve or impose conditions for approval on the case in question. If the findings in fact are not evident, then the request will be denied. Case planner will make a brief overview of the case and make a recommendation. Please, Mr. Duong.
Thank you. Good morning, Mr. Collin, and good morning, everyone. The first item before you today is located at 3460 Las Palmas Avenue. This subject property is located in what is known as the Spa Heights neighborhood. The property is zoned R1 Floor Area Ratio District 2. So this is a single-family zone, generally flat land. The subject lot is a rectangular lot consisting of 6,500 square feet of buildable area. The property was originally developed in 1930 with a single-family residence and a detached garage. However, on October 11, 2010, which is not that long ago, a structural fire broke out on the property while performing work on a building permit issued by the Building and Safety Division for work done to the front of the house. The fire essentially damaged the residence. Currently, the home is not livable, and the property owners are choosing to reconstruct the house and maintain the existing two-car garage. Now, just to explain the reason for the variance actually is to maintain the existing garage while constructing a new house, while the garage is not meeting the current standards of 20 by 20 interior clearance, and also exceeding the height limit of 15 feet. Per the zoning code, when a project is proposing to construct a new house, all buildings on the lot need to meet today's code, current code. That includes the garage, any other accessory structures such as patios, cover, gazebo, and the like. In this case, the applicant is proposing a brand new house, but the house will meet all current zoning standards, so there's no issue there, which is an improvement over the existing condition. However, the request to maintain the existing two-car garage is contrary to the code because, again, as I stated earlier, due to interior clear space of the garage and the height. The existing garage is 16 feet 8 inches high, and the interior clear of the garage is 17 feet 10 inches in width and 18 feet in its depth. And again, the minimum required by the current code for the interior clear space is 20 by 20, and the maximum height is 15. The proposed house is generally similar in design as the original house, which reflects influences of the Tudor style. And the same with the garage. I think this is where one of the main reasons why the applicant is proposing to maintain the existing garage. If I can walk through the plans for you. Again, the proposed house is generally located in the same areas as the existing house. As you can see, it's all meeting the setback and it's within the limits of the zoning code in terms of its lot coverage, the height of the house, as well as the livable area. However, the garage is located at the back, and additionally, there are features on the lot that plays a role in terms of constructing a new garage that meets code. You have a swimming pool located in the rear yard, and also you have a difference in grade. The driveway and the turnaround area in front of the garage is actually lower than the slab where the pool is located. So there's a couple of steps between the two areas. So if one is to expand the garage, you're looking at expanding it to the side to gain the width and also to the rear. In doing so, you're affecting the relationship between the change in grade, meaning that those two steps shown on the plan would probably have to be removed or relocated if possible. And also it may affect the surcharge between the pool and the building. Now the garage, if it is to be expanded, it'll be located closer to the water line of the pool. So from the building safety perspective, it creates problem with building surcharge. Okay. Additionally, it has been the planning division administrative policy to accept a 16-foot wide, 18 deep garage under an addition proposal. Now, granted, this is not an addition. This is a brand new house. But in that situation, if it was an addition, we would accept a 16-foot wide by 18-foot deep garage as a two-car garage for an existing detached garage. While this is not an addition, I believe it's reasonable that this could be tied to that same reasoning. First of all, I mean, there's a couple of benefits. First is because the garage will meet or will be consistent with the architecture style of the proposed residence. And also the size, even though it's not meeting a 20 by 20 clearance, it's meeting the intent of the zoning code because it still allows the property owners to actually park 2 cars in that garage. So based on these reasons, staff believe that the variance could be supported, and my reason for recommending approval of this project.
I had a couple questions. The garage door dimensions, is that?
The garage door dimension meets code. I believe it's 16 by 7.
Okay. And then what about the landscaping? Are they meeting code for that?
Yes.
Minimum 40%?
Yes. I think it's a little bit over, if I'm not mistaken. I don't have the plans in front of me, but the landscape, yes, it's 40%.
Right at the
Right at the minimum.
Are there any easements at the back?
There's easement according to,
Water and
that's another reason, yes, Water power, there's a 5-foot easement. That's not just located behind the subject property, but other properties also, because it spans across the rear of the various properties along that row.
And water and power was comfortable with the existing garage location
Yes.
as it is?
Yes. And to add to that, I also received a letter of support from the neighbor located directly to the rear of the subject property supporting the project. I believe his name is John C. Rock.
Jeff Searock.
Jeff
Yeah,
C.
I
Rock.
have that
I'm
letter.
sorry, yes,
Staff, did you have any other thoughts or comments?
Well, I just want to say that if this request is to be approved, there should be some conditions. That obviously one design review shall be obtained prior to the issuance of any development permits for the residents. And 2, the existing garage shall be maintained for the exclusive use of parking of vehicles. And 3, if a variance is approved, the right to maintain the existing non-conforming garage shall only be valid upon the completion and final of the proposed residence.
Okay. Thank you for that.
Thank you.
I'm going to open the public hearing and ask for the applicant. I only have one speaker slip for the project. Ms. Demery Matthews, I'm going to open the public hearing. Please state your name and address.
Good morning. My name is Demery Matthews. My address is 3404 Buena Vista Avenue, same neighborhood as the property, the subject property. The desired rebuild is stemming from the fire damage repair that exceeds 50% of the original structure's replacement value. If that weren't the case, we wouldn't be addressing the garage nonconformance. It would sort of more or less be grandfathered in. So the property itself, or the project itself, is a result of something completely out of the owner's control, whereas a lot of projects you see are homeowners wishing to, add on to their homes and do things like that, and therefore asking them to bring something, a separate structure up to code may be more applicable. In this case, the garage is the only structure on the property to survive the fire, and that is one of the reasons they'd like to maintain that structure and not lose that in addition to all their other loss. In addressing the findings, how will this strict application of the provisions of any such ordinance result in practical difficulties or unnecessary hardships inconsistent with the general purpose and intent of the ordinance? Well, in reviewing the configurations required to meet code, it becomes clear there is no way to meet code without resulting in massive practical difficulties with which Mr. Duong went over. There's a domino effect required to meet code that leads to basically the demolition of the entire existing garage. For the purposes of reducing its peak just by 1.8 feet and increasing its width and depth by the depth by 2 feet to bring it up to current code, although it meets the 18 feet that would be the requirement for an addition. And the width exceeds the 16 feet that would be the requirement for the addition. It exceeds it by 1 foot 10. However, to bring it to current code of 20 feet, we're talking about 2 feet 2 inches. So, where was it? The existing garage attic is currently a useful storage area for the homeowners, so lopping that off or reducing that presents a hardship for them. Rebuilding a new roof with less of a slope in order to reduce the height would render that attic useless. It would also change the style of the architecture of the structure, something which they are trying to maintain because it fits within the neighborhood. Like several other houses in the neighborhood, the original house was built and permitted with the detached two-car garage at the back of the property. The existing height has not resulted in any complaints from the neighbors. The existing pool deck, steps from the driveway up to the pool deck allow for just currently a 2 foot 2 inch passage between the water's edge and the steps and the structure. To increase the size of the garage to the width would mean, like I said, enlarging it 2 feet, 2 feet 4 inches to the north. And then the existing gap between the garage structure and the south the existing gap between the garage structure and the south must remain in order to construct the new structure, because there's a neighboring garage right there. So we'd have to go to the north, and such a change would reduce an already tight passage along the pool's edge. These are points that I believe were already brought up. Substantial changes, as outlined above, create practical difficulties, unnecessary hardships, and a waste in terms of required demolition alone, not to mention hardships associated with the rebuild of an otherwise unaffected structure with all or little benefit to the public. I know the board is not particularly concerned with the cost, but obviously tearing down this building and rebuilding would not be covered by insurance because it was not damaged by the fire. This homeowner was not planning to invest this kind of money in their home. They need to use insurance money to make this repair or rebuild. The next finding, what exceptional circumstances or conditions apply to the property involved or to intended use or development of the property that do not apply generally to other properties in the same zone or neighborhood? I would like to go to the required findings that Mr. Duong found on this. Basically, the differences with the subject property and other properties is the swimming pool, and the fact that the home was damaged by fire or structurally rendered useless by fire. And the other issue is that the home is Tudor style, therefore steeper pitched roofs, that adds to height. So trying to bring it up to code would affect all of that. It would affect the pool, which other neighboring properties don't have to deal with. It would affect the architecture of the Tudor, which other properties are similar in character, but they aren't all steep pitched roofs like this one. And other property owners are not facing a rebuild due to fire. Why will granting the variance not be detrimental to public welfare? The existing garage was not affected by the fire and requires no structural retrofit per structural engineer's post-fire report. Granting a variance will allow the existing garage to continue serving its purpose as an enclosed, covered, two-stall parking structure, which poses no detrimental effects to the public welfare. This property should not be penalized by the fact that the majority of the original structure was lost to fire. You mentioned landscape. The proposed design cannot proceed with a conforming garage because the proposed design already goes to great extents to add landscape in order to meet the 40% requirement. And a larger garage would throw the landscape calculation off in the wrong direction, reducing overall softscape on the property. When you look at the picture and you see the green, it doesn't quite look like 40% because, as I learned at the city, we can calculate pool as softscape, which is indicated gray there. Really should be indicated green. The pool and softscape as it exists in the proposed is 40%. In order to do that, the proposed main house had to change architecturally. We had to lop off portions. We're getting back that square footage in a second-story addition. So we have made efforts. I've worked with the landscape architect to make efforts to actually increase the landscape. And increasing the size of the garage would change that in the wrong direction. Let's see, the photo survey demonstrates how 2 cars can park within the 17-foot 10 width with its 18-foot depth. And in cases of non-conforming status, the city accepts garages at 16 feet and 18 deep. So the garage does exceed this requirement by 1 foot 10 in width. This property, okay, I already mentioned that, should not be penalized. And lastly, the fourth finding, why will granting the variance be in keeping with the objectives of the ordinance? The neighboring properties will not benefit from the reduction of the roof peak height in terms of sightlines, nor will they benefit by increased sunlight. The structure is shadow cast only upon the homeowner's property from that garage peak. The existing height is also not high enough to create a habitable space under the garage roof line. The existing attic will remain as usable storage room only. And the existing 17-foot 10 wide and 18-foot deep garage can currently hold the 2 cars. As variances are considered on a case-by-case basis, it makes sense that when the code intent is met, parking 2 cars in there, the request is not precedent-setting, and the granting of the variance would be beneficial to the neighborhood and the public, that such a variance proves warranted. Statement of additional facts. Because this project will be constructed as a result of a fire that destroyed the original house, the homeowners are concerned that the insurance company will not pay for the rebuild on the garage. I just wanted to reiterate that. It would pose a significant financial hardship, and while such a hardship is often disregarded during variances, in this case it's worth considering. And the other thing I wanted to add is originally we also applied for a setback variance on the main house because they were hoping to reuse existing footings as much as they could. Again, an effort just to use what hasn't been damaged by the fire. And the homeowners, in working with the planning department, conceded that. They said, okay, fine, we'll rebuild the house, bring it completely up to code in terms of landscape and setbacks. And they're lopping off 1 foot of their house. They're having to rebuild foundations because of that. And so they're saying that they want to work with the city to bring this property up to code slowly and over time, which I believe is the intent of the city. And the garage is just the one thing they're hoping the city will allow a variance on.
Okay.
Do you have any questions, or what? Is that it?
I can't think of anything yet. So
Okay.
Thank you.
Thank you.
Okay, that's the only speaker card that I have. I would like to note that comments were received from the city departments, but no concerns were expressed over the proposed project. And also, as Mr. Duong had mentioned, I have received a letter from Jeff Searock, located at 3461 Rosemary Avenue, in support of the project. So, seeing no other people wishing to speak on it, I'm going to close the public hearing. And although quick questions, the applicant understand, Demery, I'm sorry. Does the applicant understand and agree to the conditions of approval as recommended by staff? Based on the findings recommended by staff, facts and information presented at the hearing, and other applicable department input, I am recommending approval of the subject variance. After the hearing, the decision will be prepared in writing and will be in the form of a letter sent to the applicant and to all persons who respond to the public notice, either by speaking at this hearing or by submitting written responses, and have provided their name and mailing address. The date of the decision will be the date appearing on the letter. As it relates to any possible appeals under the appeal provisions of Title 30, Chapter 30.62 of the Glendale Municipal Code. The decision may be appealed to the Planning Commission within 15 days of the date of the decision. Anyone wishing to appeal may obtain forms and brochures on the procedures from the Building and Safety Section Permit Services Center located in the same floor of this building. As mentioned, this particular hearing is closed, and thank you very much for coming for that part. Move on to the second hearing or case that we have scheduled, and that's project located at 964 East Glen Oaks Boulevard. Again, I only have one speaker card. Or is there anyone else in the audience that would like to speak on this case? Okay. Okay. The proposed project is a setback variance or a standards variance to allow non-conforming 5-foot 2-inch interior setback where a 6-foot interior setback is required for an existing 491 square foot detached guest house. Project's located in R1 low density residential zone, floor area ratio, District 2. As it relates to comments from other departments, the departments that responded to the request have stated that their standard conditions or comments will be applied to the subject project. And these are typically code requirements. Nothing special as per the request. I've received one letter from Wayne and Rachel Boone, located at 960 East Glen Oaks, for stating that they have no objections to the variance request. At this point, I'll ask for the case planner to give us a brief overview of the case and their analysis. Mr. Duong.
Thank you again, Mr. Collin. As you stated, this is a standard variance to maintain a non-conforming interior setback for the existing guest house located somewhat at the rear of the subject property. Again, the subject property is located at 964 East Glen Oaks Boulevard, Zone R1, floor area ratio District 2, and this property is located in the Rossmoor neighborhood. The subject property was originally developed with a single-family residence located at the front of the lot, a detached garage, and a guest house. The guest house in question was constructed in 1948, and there's a permit that reflects that project. However, this project in some regards is similar to the one you just heard. This issue came up as a result of a construction that was approved and a building permit issued for some addition to the rear of the existing house, as well as some addition and modification to the front. In the course of exercising this permit, the owner discovered that the exterior walls were damaged or dry rot by termite. Therefore, he proceeded to remove the exterior walls and roof. resulting in more than 50% removal of the exterior walls and roof. When this happens, according to the zoning code, the subject property loses all of its legal non-conforming rights. So that again applies to all buildings on the lot. So applies to the house, to the guest house, and to the garage. In this instance, the house will be rebuilt. And as proposed to staff, it will also meet all current zoning code in terms of its setback, its height, its floor area ratio. The garage, because it's detached from the house, our zoning code recognizes that as still being a legal garage, meaning there's no required setback requirement, minimum setback requirement for a detached garage. And the garage is fairly new, so it meets the size and width minimum for a two-car garage. And the proposed project for the house would not require a third-car space. So that's not an issue. The issue, because the modification to the primary residence, which is the house, which causes the entire property to lose its non-conforming rights, the question that we're looking at today is the guest house only. The guest house, per today's code, even though it's been in existence since 1948, we would have to look at the project as if it's being constructed today. And today's code would require a guest house detached from the residence in this zone to be located 6 feet from the interior property line. That includes the rear property line. So in this case, the property line, the guest house is located 5 feet 2 inches away, which is 10 inches short of today's code. Again, the guest house is located behind, will be located directly behind the primary residence. It's a one-story structure, while the proposed new residence is a two-story structure. So in that regards, the guest house will not be visibly seen or readily seen from the street, maybe for a couple feet if you were to stand directly in front of the house. You can see two feet of the side of the guest house projecting from the side of the main residence. The guest house has been in existence, again, as I stated earlier, since 1948 and has not caused any detrimental effect or impact to the adjoining neighbor. So the request to maintain its location at 5 feet 2 inches will not change the situations that's been around for many years. And again, as it will not be seen from the public right away. And given that this is a technicality in code, since the work is not proposed for the guest house at all, this is mainly a project concerning the rebuild of the primary residence. Staff believe that it is sensible, again, to maintain the guest house where it currently is. And we recommend approval of the standard variance for a 5 foot 2 inch setback for the guest house. And that concludes my presentation. If you have any questions, I'm available to answer them.
Yeah, one quick question. Quick note that this is for the audience and those watching is for 964 East Glen Oaks Boulevard, which is standards variance case number PVAR 2011-013. One question I did have, the existing separation between the guest house and the garage, do we happen to know what the eave-to-eave distance is?
The eave to the eave distance, that was, I met with a representative from the firm that's working on this project. I don't have the exact number, but he gave me some drawings. Maybe the applicant can speak to that, but it meets the required 5 foot minimum separation eave to eave from the guest house to the garage. However, if I may add, there is a problem with the separation between the guest house and the residence. But in this case, because this is a minimum code requirement, and the house will be brand new, that house could be set back further to make up for the distance when the project goes through design review as well as plan check.
Okay.
So that could be made a condition of approval, even though it's a zoning code requirement.
Okay, thank you. Going to open up the public hearing. We have one speaker card from Oxon. If you'd like to come up, please state your name and address for the record, and also if you can address the four required findings, please.
Good morning, Mr. Collin, Mr. Doc. My name is Oxen Babakanian. I'm principal of Oxen & Associates working on this project. My colleague Art was on the project, but he couldn't make today, so I'm the applicant here. The granting of this variance would really not jeopardize any of the four findings that we want to pursue. The first one being the strict application of the provision of any such ordinance would result in a practical difficulties or unnecessary hardships inconsistent with general purpose of intended ordinance. Because this guest house has been built since 1948. It's been there for 60 years, has not provide any difficulties for the neighbor. Neighbor's garage is a detached garage. It's right across from that same guest house. So it's very, it's been a guest house, a garage and guest house living together for the last 60 years. If we try to use this ordinance, it would really try to create a lots of hardship for the owner first. Second thing would be if we cut 10 inches from this 491-inch square foot guest house, we really demolish, living quarters and a bathroom. So you cannot call it guest house anymore. So it basically for 10-inch requirement, we're requiring to demolish the whole building as such. And I don't think that's the intent of the code or this ordinance to do that for 10-inch. And this is, Second thing is there are exceptional circumstances or conditions applicable to property involved or to the intended use or development of property that do not apply generally to other properties in the same zone or neighborhood. The condition, again, I mentioned is that 10-inch, by cutting the building 10 inches, we're forcing the building to be not a guest house anymore. The rooms will not fit right because there's 490 square feet. The bathroom is not going to fit. Basically, we're going to demolish the building because of that 10-inch requirement, because we're 5'2" versus 6 foot new code requirement. And by the way, this, as Mr. Dunk beautifully put it, this is a technicality in a code that we're requiring all the accessory buildings to submit to original building. Although the accessory buildings or guest house had its own permits, have been being there, but just due to the result of bringing this new building per code, and we have to do the same thing to existing permitted buildings. It creates lots of difficulties, and so I think this is an exceptional, so it makes it easier if we leave the things when they are and not to use this ordinance to bring it to the code. The granting of variance will not be materially detrimental to the public welfare or injury to the property or improvements such as zone or neighborhood in such the property is located. This is true. This building, since being a guest house, being back of the main building, being close to the existing neighbor's garage, it's such a mute point as far as the creating any material difficulty or to the public welfare or injuries to the site or any improvements to the neighborhood, that it's not really 10 inches would not be as, will not create any much beautiful building as or anything else. So I think that may cause more injuries than try to not keep it. Fourthly, the granting of variance will not contrary to objective ordinance. Basically, although the ordinance says that we need to, because of the existing new building is because of the 50% construction issues, we're creating that as per new code. Although we're not literally meeting the 6-foot clearance interior setback, but due to difficulties that is going to create to cut that 10 inches, I think in this case it is viable and it is probably acceptable to use that 10 inch and not use the true really the true meaning of the code rather than a strict confirmation of it. The code is not asking us to demolish the whole building just because of 10 inch. It just, the intention is to create some more air and separation between the two buildings. If it was the neighbor building was residential, there would be something to say because living people there. But since it's a garage, the garage separation is not as important as if there was a house there. I think that's Dong put it very nicely as far as all the condition was started this whole thing, and I don't want to repeat that same situation. One thing I should add is this owner, because not knowing the code fully, he intended to do something better, but instead he just shot it in his foot. When he discovered that his main house, when he had a permit to rebuild his main house and do the addition, his house was all the exterior walls was very badly damaged by termite. Rather than asking any officials or us for guidance, he decided, well, this is old walls, why can I remove and put a new wall? In not knowing that Glendale has its own codes and there is requirements to do so. Just because of one mistake, he is paying dearly for it. First, he has to demolish most of his house. We have to go 9 months of DRB and new preparation for a new building for instead of in his old building which was permitted legally and everything, just because he moved one wall, and it is it's against the Glendale code, but he not knowing that, he caused this injury to himself. So last few months, he's dealing to live in a very dire situation and cost of trying to rebuild this new house. Then we have this variance pending, which is it's for existing permitted units again. So therefore, one mistake caused him dearly, and he's going to be out of house for another maybe a year before everything is done. And I don't know if there is any better way to inform public of these situations, that don't touch any of your stud wall if they're even eaten or damaged, or don't touch your footing if they're damaged, because of the code is going to get you. And there is something missing between the public awareness and people and actually the city, that they should know the codes, or they should be really something publicly said to the residents of Glendale that, hey, you should not touch your walls. You should not do anything to exterior or interior of your building before getting a permit, before knowing what you're doing, because that really creates hardship to them. And it really creates hardship and creates a havoc on the family members trying to live in the situation that Mr. Ginosian is, not having a house, now having this variance situation which is prolonged the condition of the building the new house. I'll cut on this one. I don't want to go too far, and I appreciate your time, and hopefully you'll give us the grants for this variance. Thank you.
Okay, thank you. I do have some questions for you if you have a moment.
Sure.
First question is, what is the separation between the garage and the guest house, the eave-to-eave distance?
If the eve is 5 foot, the garage to the guest house is 6 feet. The buildings are 6 feet apart. The eve to eve is 5 feet apart.
And then the original permit from 1948 shows a 14 by 24.
Yeah.
But when you look at the plans, it looks like there's a 2-foot deviation, and it's gotten like 6 feet longer. Do you happen to know what might have happened?
That I have no, I don't know there was a discrepancy between that. I didn't, because we didn't do a code research to what was the existing guest house versus what, but all I know is 491 square foot.
Okay. And my third question is, you were mentioning that if one wall, which was the wall for the interior property line,
Yeah.
had to be moved in 10 inches.
Yes.
Is it not true that you could shore up the existing roof to be able to move that wall in 10 inches
as
without
far as-
having to demolish the whole thing?
Yes, no, that can be done. We can move physically 10 inches in, but that what would do is destroy the size of the bathroom. Then they cannot have a bathroom there, and will make the living room much smaller. It's a very tiny building. It's 491 square foot.
And that dimension across now, where the bathroom's located, is 14 feet across,
Yeah,
approximately?
Yeah.
And does the whole bathroom
The
go...
bathroom is, there's a bathroom there, and I've not gone. There's a closet, bathroom, and the living room. The living room is very narrow. Those are. If we move all of this, first we have to put in new foundations. We cannot just move it in. We have to put a new foundation. We have to cut the roof. We have to do all the structural requirements for the exterior and make the rooms much smaller than it is. It's only 14 feet width, actually the main house, and then the bathroom is smaller than that. If you have the drawings. Okay, so there's the drawings of the guest house.
Yeah, I have them.
So you have to demolish that interior wall also. Okay, I'll show you. This is the bathroom. There is 5 feet here. If we cut this 10 inches, the 5 feet we don't have. The 5 feet is minimum requirement for a bathroom. So if we cut that 10 inches, then you have to remove this wall too. And makes the bedroom, it's already 9 feet width. So by the time you cut it, it's going to be a non-legal bedroom anymore.
Well, it's not supposed to be a bedroom, it's a guest house.
Guest house, yes. I mean, it's going to be not even functional room anymore, it's just going to be a closet.
Okay. The other question I had is, when I went out to inspect the property, I noticed that it's got horizontal siding on it
Horizontal siding?
around the exterior of the guest house. Has it always been like that? Has that been recently painted, or is that new siding?
Painted, yeah.
Okay, the last question I have is, what were you proposing to use that side yard for between the guest house and the side property line?
Yes, that's not usable, it's just empty space. Do you have anything on there? Nothing? It's just,
Any thoughts as to what you would put in there?
I don't think he's going to put any air conditioning or nothing. Just going to be open.
So possibly
should be-
landscaped?
I think we're proposing for this new building that we're putting up there, put more landscaping there. So probably it's going to be more landscape.
Okay.
Because we need that landscaping.
All right, thank you very much.
Sure, thank you.
Mr. Collin,
Yes.
if I may suggest something concerning the size discrepancy of the guest house, what shown on the drawings behind you and what was submitted to us and the application or the permit that was issued in 1948. Maybe the owner could explain if he's aware of any changes he's made to the house himself or to the guest house, why there's discrepancy in size, as Mr. Collin noted.
Hold on, you have to come up to the front, and then we'll need a speaker slip filled out. You can fill that out afterwards, but I'll definitely need that. Please state your name and address.
My name is Ani Jinosian. My address is 964 East Glen Oaks Boulevard, Glendale, California, 91207. And we purchased the house in 2008 in the condition. The guest house was the way it looks today, in that condition.
In 2008 is when you
Yes.
purchased the property?
Yes.
Okay, so there's no information that you may have as to how it ended up to be that shape as
No, actually.
relationship to what was
This is the
before.
first time I'm hearing that there is a discrepancy in the permit and the way it is today. It's my first time hearing it.
Okay, thank you very much. And if you could
Thank you.
fill out one of the pink slips at the front, that would be great. Thank you.
And also, if I may add, if your decision concerning this request is consistent with staff recommendation, staff recommends that conditions be placed on this project. And some of the suggested conditions would be similar to what I've stated for the last project you heard, which is design review approval shall be obtained prior to the issuance of any development permits for the residents. The existing garage shall be maintained for the parking of vehicles. And if the variance application is approved, again, the right to maintain the existing non-conforming guest house shall only be valid upon the completion and final of the proposed residence. And lastly, the guest house shall not be rented.
Okay, I did have one quick question, and those are good conditions. The original project, was that something that was exempted from the design review process, or did it go before the board?
Correct. The original project that staff approved and presented to us and ultimately received a building permit was exempt from design review, and that project was discussed and worked through with the urban design studio before the design review exemption was given.
Okay. At this point, I'm going to close the public hearing. I have no other speaker cards. And I'm going to take this case under submission. So, thank everybody for coming. Appreciate your input. And a decision will be coming out soon.